just as our founding father George Washington said in his farewell address, that these rights are sacredly obligatory upon all, both individually and collectively. So the rights that are contained within the Constitution, those are our rights. And so when a state does create a law, commits a seditious act, brings into place the seditious law, then what happens is that they then direct their agents, right, the prosecuting attorneys, to charge in a different way, to act differently. Well, there's a couple problems there. And so when you go to Article 1, Section 10, Article 1, Section 10 says that no state shall create any law that shall impair the obligation of contracts, right? So when the state created that law, remember, a prosecutor enters into their office. They make a promise through the oath that they take. A judge enters into their office. They make a promise based upon the oath that they take. That promise is for a future outcome. So when the judge says, well, yeah, I will do what the Constitution of the United States says that I'll do, I will support and defend it, I will be obligated thereby anything in the Constitution, such as it states within Article 6, then that's the obligation, right? That's what they got to do. And so now they've created a contract by and between the people, promising a future outcome, right? Promising to produce a future product and be bound by certain obligations, right? Those obligations are the law and the Constitution. So what happens then is that when a state then enacts a law and says to the judge, you don't have to do this, well, guess what? That law is impairing the obligation of the judge's contract. Therefore, it's a direct violation of Article 1, Section 10. You cannot create a law that shall impair the obligation of contracts. And yet every single time a state creates a law that is in conflict with the Constitution of the United States, that would be a law that is impairing the obligation of contracts. Whether it's the prosecuting attorney that made the promise, whether it's law enforcement made the promise, whether it's the judge that made the promise, if the state creates a law that impairs their ability to be able to produce, to be able to deliver on the promise they made, to be bound thereby anything in the Constitution, well, that's an unconstitutional law, in violation of Article 1, Section 10. So we don't even have to go to the 14th Amendment, although I do stick with the 14th Amendment anyway. So when the state does create that law and directs their agents to enforce that law, when the agent then makes the decision to rely upon the inferior state statute to deprive a person right guaranteed by the Constitution of the United States, they just committed a crime. It's called deprivation of rights under the color of law. It's Title 18, subsection 242, which states, any person who, under the color of any state statute, ordinance, custom, or regulation, deprives any person of your rights secured by the Constitution, commits that crime. So when they commit that crime, thus depriving a person of right guaranteed by the Constitution, the prosecutor, when they bring that charging instrument, the incorrect one, charging by way of information, not by indictment, as required by the Constitution, when they bring the incorrect charging instrument to the judge, remember that judge, he has a duty and obligation to ensure the power he exercises is consistent with his authority. If he chooses to exercise his power based upon the prosecutor's abuse of power by bringing the incorrect charging instrument, relying upon an inferior state statute to do so, then guess what? That judge has just committed a crime as well. Deprivation of rights under the color of law, because he's now depriving the person of a guaranteed right that's brought by it, but he's also established a conspiracy to deprive the rights by and between himself and prosecuting attorney. Title 18, subsection 241, which states when two or more persons conspire for the purpose of depriving any person of rights secured by the Constitution commits that crime. So now we have a criminal conspiracy that's been established by and between the judge and the prosecuting attorney because of the state creating a law, directing their agents to act unlawfully. Now you have a criminal act and criminal conspiracy that's been committed in the pursuance of an outcome. And remember, a simple maxim of law is any act unlawful at the beginning cannot become lawful over time by subsequent legislation. If government commits a crime in the pursuance of an outcome, that outcome is unlawful, it is unconstitutional. So when the judge then orders the individual to be held over for this offense, right, when he signs an order for arrest, guess what? The Constitution states no person shall be held to answer for capital or otherwise offense crime unless on presentment or indictment of a grand jury. The moment that the individual was ordered to be held, the crime was established. It was the judge that did it, and now that judge has taken that order and is handing it off to an executive officer, being the police officer, and saying, here, please go out and arrest this individual. Well, guess what, guys? That officer also has a duty and responsibility to ensure the power he exercises because it's with his authority. If he chooses to exercise his power based upon the judge's abuse of power, relying upon the prosecutor's abuse of power, by relying on an inferior state statute to deprive a person right guaranteed by the Constitution, that officer is also guilty of the exact same crime. Not only that, but he's now a part of the criminal conspiracy because he has abused his discretion by not following the obligations that he has. Then, when they go out and perform the arrest on the individual without having the proper documentation in place, the crime of kidnapping has occurred. And this is a federal offense, Title 18, subsection 1201, because the individual is being held over for ransom in the form of bail. And so now, anytime you have a deprivation of rights under color of law that occurs in conjunction with a kidnapping, we know that the punishment as prescribed by law is death. That is the punishment that is already within the code. So now we have a very serious offense that's occurring across 13 states, and then another 28 states. That this is a very big deal, huge deal, because there's more than 700,000 people across the United States of America today that are being held illegally and unconstitutionally in these institutions because these judges, prosecutors, and law enforcement are relying upon an inferior state statute to deprive a person right guaranteed by the Constitution. So when you deal with abuse of discretion, because that's what's happening, the judge is abusing his discretionary authority with which he's vested in law. So when you deal with abuse of discretion, okay, and you want to know about what it is, you would go to the Circuit Court Handbook, United States Circuit Court Handbook. And in the Circuit Court Handbook, it describes a two-part test to determine whether or not there's abuse of discretion that has occurred, okay? The first part of the test is, did the judge render a decision? Did he apply the incorrect test? Well, he did, but I'll explain to you in just a moment in a separate example why he did. But let me go ahead and say, the second part of the test is, any erroneous view of the law is an automatic abuse of discretion. Go out to the Circuit Court Handbook, you will see for yourself, any erroneous view of the law is an automatic abuse of discretion. Now let me tell you what an erroneous view of the law is. That in the judge's legal contemplation, that the inferior state statute that permits him to be able to proceed without an indictment by a grand jury is in legal contemplation superior to the guarantees of the United States Constitution, that would be an obvious erroneous view of the law. Therefore, an automatic abuse of discretion has in fact occurred, and by that abuse of discretion, guess what? There are 3 crimes that occur every single time a public official commits abuses any discretionary authority with which they are invested in law. The first crime is perjury, because he's failed to fulfill a promise. He made a promise, he's not doing it, and he's already implicitly invited punishment in the form of perjury should he fail to fulfill such promise. Therefore, his knowledge, his willfulness derives from the promise he makes. You make a promise to do something, you fail to fulfill that promise. By your breach of fulfilling the promise, you're already guilty. That's why public officials' crimes are per se. You don't have to take a finding of facts. There's no trial. All you got to do is just say that they show that they had an obligation, they failed to fulfill the obligation, and by that breach alone, all elements of crime have been met, period. Okay? So that's why Article 3 of the United States Constitution says that the trial of all crimes, with the exception of impeachment, shall be by jury. Right? Because impeachment does not require a finding of facts. There is no trial that has to occur. All you got to do is show that they had an obligation, they breached that obligation, and now they can no longer be trusted by the public because they have failed to fulfill such a promise. They're guilty, impeached, done. Okay? So public officials do not get a trial. So that's issue number 1. All right. Now, so any erroneous view of the law is an automatic abuse of discretion. The first crime that they automatically commit is the crime of perjury, right? They're already guilty of that. The second crime is extortion, because extortion is compelling a result through illegal means. So when a judge abuses the discretionary authority, when he breaks the law in order to compel a result, that would be compelling a result through illegal means, right? So when you don't follow the law, you don't follow the Constitution, you don't do what it specifically states you must do by having an indictment by a grand jury before arresting someone and holding them over for this offense, that is breaking the law. You just broke the law. That's a crime. And by your crime, you have committed the crime of extortion automatically because you compelled a result through an abuse of your discretionary authority. That's number 2. Now, the third crime that is automatic is the crime of oppression, because you are treating 2 people in like circumstances differently because you are in a position of authority. You're committing tyranny through the oppressive acts that you are committing. Those are 3 crimes, automatic, no matter what. Every single public official that commits these, that abuses any discretionary authority with which they're invested in law, commits those crimes. Okay? So by the abuse of discretion, right, the moment that they perform an arrest without having the constitutional authority to make the arrest because they don't have the proper documentation in accordance with the requirements of the Constitution, that makes that arrest unconstitutional, which means that everything that derives from that arrest must also be unconstitutional because it is all tainted by the illegality of the way it was obtained. If the arrest is unconstitutional, then that means that everything that derives from that arrest must also be unconstitutional because an unconstitutional act cannot result in a constitutional outcome. If you don't follow the rules, you don't follow the Constitution, then what you produce is going to be unconstitutional.